Morning, everyone, and welcome to today's webinar on beneficial ownership affected companies. My name is Simon Fenyani from Corporate Education and Voluntary Compliance, and I'll be the facilitator of the program today. You are welcome to post questions on the chat box of the StreamYard. And I will also share the beneficial ownership email on the chat box. In the studio, we have Ms. Lucinda Steenkamp, Senior Legal Advisor, Corporate Legal Deputy Information Officer, who will be doing the presentation for us today. Furthermore, we have Mr. Ruzani Mahwasana from our communications unit. So the recording of this webinar will remain on the Facebook and YouTube, should you wish to view it again later. I will now hand over to Ms. Lucinda Steenkamp to present to us. Thank you. Over to you, Ms. Lucinda.
Thank you very much, Simon. Good morning, everybody, and welcome to this beneficial ownership webinar on affected companies specifically. We are hoping that this presentation today will provide you with a bit more guidance on the type of category that a company needs to select when they are submitting their beneficial ownership declaration. Okay, so just shortly, what is beneficial ownership? I'm sure we are all aware of the requirements. Simplified though, a beneficial owner in respect of a company means an individual. This is a natural person who directly or indirectly ultimately owns that company and importantly exercises effective control of that company. So it's not only ownership, but also talks to control. And this can be facilitated through the holding of beneficial interest in securities that has been issued by that company. Section 56 of the Companies Act, where the company's issued securities may be held by one person for the beneficial interest of another person. Also through the exercise of or the control of the exercise of voting rights within a company. Section 37 of the Companies Act explains it, where each share issued by a company has associated with it at least one general voting right, except if it's provided otherwise for by the Act or the MOI. So voting rights are provided at least one general voting right in the company's voting rights, unless the MOI or the Act provides otherwise. A third one is the right or control of the right to appoint and remove directors. Section 66(4) of the Companies Act indicates that an MOI of a company may provide for the direct appointment and removal of one or more of the directors by any person who is named in or determined in terms of the MOI of the company. So what this means is, in terms of an MOI, a specific person can be named in that MOI who has the power to appoint or remove directors of that company, or it can be saying that the chairperson of the board may have the power to appoint and remove directors. So that is someone that can be named specifically. Lucinda Steenkamp is named in the MOI of the company with that power, or a position, ex officio position that can be named with that power. That is effective control and therefore a beneficial owner that needs to be declared. And lastly, the ability to otherwise materially influence the management of the company. So in terms of Section 66 of the Companies Act, the business affairs of a company is managed by its board of directors, which has the power to perform any function of the company. This is effective control, where they have material influence in the day-to-day management of the company. So here's just to give you a quick oversight of, this is not an exhaustive list, but it gives you an oversight of the different beneficial owners that you can encounter in a company. As I mentioned, shareholders is the main one in terms of ownership, where we also have beneficial interest. Board appointments, section 66(4), where I indicated a person can be named to appoint or remove directors. Voting rights, the enjoyment of assets, it's a manner of ownership in terms of a company. Profit sharing agreement may be in place that allows a person to share in the profits of this company, which means that there is a matter of ownership applicable. Directors and trustees in terms of trusts. So although trusts is a heuristic person that's not registered with the CIPC, it's registered with the Master of the High Court, but the trustees and the beneficiaries in terms of the trust are beneficial owners or exercise effective control over the trust that may be a shareholder in a company, and then of course any other influence that's not defined. As I said, not necessarily an exhaustive list. So the difficult one, what is an affected company? So an affected company in terms of the legislation means a regulated company as set out in section 117(1) Roman 1 of the Companies Act, as well as companies to which affected transactions and offers and the takeover regulations apply, as determined in terms of section 118(1) and 2 of the Companies Act. So those sections are quite complex. So in order to simplify, we broke it down for you in an affected company, therefore includes a public company. So a public company is an affected company, whether it's listed or unlisted. You have a state-owned company, which is an affected company, except in the case of exemption by the minister. So there is a process where state-owned companies can apply to the Minister of the DTIC for exemption in this regard. A private company only in terms of the transfer of securities when exceeding the percentage prescribed by the minister, which is 10% within a 24-month period. Now, what this means is where a private company transferred more than 10% of its securities within a 24-month period before the declaration of beneficial ownership, then that private company is also regarded as an affected company. Or a private company that is controlled by an affected company, so control or exercise the majority of the voting rights, the right to appoint or control the appointment of directors who control the voting rights at board meetings, etc., or a subsidiary majority owner of an affected company. So where a private company is the subsidiary of an affected company, the affected company is the majority shareholder of this private company, then that private company is also regarded as an affected company for declaration purposes. To give you a few examples where private companies are regarded as affected companies, say company A, which is the declaring private company, is controlled by company B, that is an affected company. Due to the fact that company B, the affected company, is able to exercise or control the exercise of the majority of the voting rights associated with the issued securities of the declaring company A, or that affected company B has the power to appoint or elect or control the appointment or election of directors of that private company who control the majority voting rights at the board meeting. That is where that private company will then be regarded as an affected company due to those requirements where the affected company controls the private company. Another example where company A is a subsidiary of company B, that is an affected company, meaning that company B, the affected company, owns 51% or more of company A's issued securities. So examples of being considered affected companies is where the affected transactions come in terms of section 117 that is listed in the Act. Transaction or a series of transactions done by the regulated company, a public company, state-owned company, or private in terms of the definition that it was provided earlier, amounting to the disposal of all or the greater part of the assets of the company, where you have an amalgamation or merger where at least one regulated company or affected company is involved, a scheme of arrangement between a regulated company and its shareholders, the acquisition of or the disposal of beneficial interest in the voting securities of a regulated company where it's more than 5%. Remember, we work on the 5% threshold, where it announced the intention to acquire a beneficial interest in the remaining voting securities of a regulated company that's not already held. So this is very high level in terms of announcement that there is securities to be acquired, or intention to acquire that beneficial interest in the securities, and that will result in an affected transaction, which would make that private company then an affected company. Okay, so we work with 3 types of categories that one person can select, that a company can select when finding their beneficial ownership declaration. The first one is the non-affected company with beneficial ownership information. These companies that are not classified as affected companies and they have beneficial ownership information to declare. This is the standard BO register requirements, and the most prominent declaration that we do receive is non-affected with beneficial ownership. Where a company is an affected company in terms of the examples provided, these companies are classified as affected companies whether they have beneficial ownership to declare or not. And there is still the upload of mandatory documentation required, but there's no BO information completed. So affected companies still need to declare their beneficial ownership through the upload of the mandatory documentation. And then lastly is non-affected companies without beneficial ownership information. These are companies that are not classified as affected companies. And once you apply the definition of beneficial ownership, it comes to the conclusion that there are 0 beneficial owners in this company. Then you select this category and still upload the mandatory documentation. Okay, so how do we select how do we know which category is the correct one to select? So in order to guide the process, there are 2 questions that a company must ask. First, the company must ascertain whether it's an affected company or a non-affected company in terms of the definition. So apply the definition in the legislation and the simplified requirements as provided earlier in the presentation to the declaring company. And ask the question, is my company a public company? Yes or no? Is my company a state-owned company? Yes or no? Is the company that I'm declaring a private company, but it is majority owned by an affected company? Yes or no? If any of those questions are yes, then the category to be selected is an affected company. If all of those questions the answer is no, then we know we are not selecting the category of an affected company, and then we need to ascertain the second step, whether it is non-affected with beneficial ownership or non-affected without beneficial ownership. Okay, Simon, for some reason there is now writing there that is in front of my presentation. Can you please remove those queries? We will deal with queries after. So once you have selected affected or non-affected, then there is certain criteria that can be applied when ascertaining whether beneficial ownership is applicable to an entity or not. So the 5% threshold that I mentioned, thank you, the 5% threshold that I mentioned that needs to be applied. Whether there is ownership in place, we deal with non-profit companies where there's no shareholding, etc., applicable. NPCs with members are not necessarily owners, but they can derive a benefit from the company, and those owners, those members can then be declared as beneficial owners, where we have the board of directors that exercise effective control. If the answer is yes to that question, then the board is regarded as beneficial owners and should be declared accordingly. So the response to these two questions will guide any company in filing its beneficial ownership with the CIPC correctly. Just to recap, make use of the simplified requirements, use it as a type of checklist. Ask first the question whether my company that I am about to declare is an affected company or not. Once that question has been answered, then you know the next step is to ascertain who the beneficial owners are and to declare accordingly. So just in short, non-affected companies with beneficial ownership to declare. This is the most applicable category, as I've said. Beneficial owners apply the definition and declare accordingly. Where you have complex ownership structures where there might be heuristic persons as part of the ownership structure, then include the disclosure form as an uploaded document and indicate what this complex structure looks like. The disclosure form is no set template. It can be in the form of an organogram, can be in the form of a table, any way that explains to the CIPC what this ownership structure looks like. The filing of a securities or a members register in the case of an NPC or a closed corporation is a mandatory document and must be submitted. Where you have NPCs without members, you still have a list of directors, and that they must have directors, and that is the list that you will upload in place of the mandatory securities or members register. For affected companies, as mentioned earlier in the presentation, you have your public companies, SOCs, applicable private companies in terms of the definition, where there's no beneficial owners declared on the functionality itself, it's not exempted from declaration. So what this means is when you select the category of affected company, the system will not ask you to declare the actual beneficial owners. It will take you immediately to the upload of the mandatory documentation, which is the filing of beneficial interest register for affected companies. Where we have non-affected companies without any beneficial ownership to declare, this is very rare, but it does exist and we have to provide for it. Where you have the sole shareholder of a company who is the sole director without any other external influence or control. There's no profit sharing agreements in place and there are no other persons deriving any benefit from this company. Then this is the category that will be selected, but the filing of a securities register of the sole shareholder is still a mandatory document that must be submitted. So just to recap what the objective of the beneficial ownership register is and why we have this register in place is to have a register of natural persons who ultimately owns or exercises effective control over legal entities. So this is a legislative requirement. Its purpose is to bring South Africa in line with international best practices and the removal by the Financial Action Task Force of South Africa from the grey listing, to provide law enforcement agencies with an accurate, credible, and verifiable register of beneficial owners of entities, to assist law enforcement with relevant information when it comes to their investigations into money laundering and who the ultimate owners of an entity are, and to hold such persons accountable, and also to mitigate the risks identified in the National Risk Assessment, where legal persons were identified as vehicles prone to abuse for money laundering and terror financing activities. So the whole purpose of the beneficial ownership register is to have an accurate, up-to-date, and verifiable register of natural persons who ultimately own or control certain entities. And then secondly, to also assist law enforcement agencies in their investigations to lift the corporate veil, so to speak, to get to the persons that are using corporate vehicles for money laundering and terror financing activities. So some frequently asked questions, these are also published on our CIPC website, so you're welcome to extract them there. Can entities file beneficial ownership declarations more than once a year? So legislation dictates that entities must file their BO declarations at least once annually. But it also dictates that the securities register of a company, which includes the BO information, must be kept up to date and to file any changes or amendments with the Commission within 10 business days of these changes occurring. So the normal process would be that beneficial ownership declaration must be done by all companies, external companies, and closed corporations at least once annually. But should there be any changes during a specific year, then those changes must be filed with the CIPC within 10 business days from the changes occurring. So how do you delete or amend an existing BO declaration? Beneficial ownership declarations cannot be deleted, and it's a criminal offense to provide false or misleading information to the Commission. However, should BO information change, such changes must be filed via an amendment whereby information can be amended, deleted, added, etc. The original information or filing still persists in terms of our accurate, verifiable, and real-time beneficial ownership register. One of the many questions that we do receive is, what is a mandate? The mandate that we are requesting is a compulsory document wherein the declaring company provides a mandate to a filer, which must be a natural person, to submit its beneficial ownership declaration on behalf of the company. So the purpose of this document is to have a single person filing the beneficial ownership declaration of a company and not having all of the directors of a specific company, for example, providing the OTPs to ensure the accuracy of the information declared, etc. So this document is mandatory and very important. The content of the mandate is, it can be in the form of a company letterhead, a resolution, a power of attorney. It must still be on the company letterhead. We've received many questions where companies indicate that they don't have a specific letterhead. We don't mean a logo or trademark or something that is on your letterhead. What we require is the content of a company information that must be on that mandate. Registered address, registration number, name and registration number of the specific company, etc. The mandate then is given to an individual, a natural person, so full names and surname, as well as the ID number of the filer, the person being given the mandate, and it must be signed by 50% plus one of the directors, and in the case of a CC, by all members. Where you have an MPC, of course, they're still directors, so the 50% plus one still applies. That's what the mandate needs to look like. So what is a securities register? That's also a mandatory document that must be filed. Securities, in terms of the Act, means any shares, debentures, or other instruments that's issued by a profit company. A securities register of a company contains all the information of the securities, including shareholding, but it's not limited to shareholding, that is issued by the company. The content of the securities register is detailed in Regulation 32(3), and it's also provided on the CIPC website, where we published template examples for you on what the securities register needs to look like, what the mandate needs to look like, and what the beneficial interest register needs to look like. I'm not going to go through all of that now in the interest of time, but that is the content in terms of the legislation that needs to be in your securities register. I want to add and stress at this point that the completion of a securities register by all companies is not something new. This is a requirement that has been in place since the inception of the current Companies Act in 2011. The only difference now is that the legislation was amended in such a way that this securities register must now be filed with the Commission. What is the beneficial interest register? So this is also defined in the Act. Beneficial interest, when used in relation to a company's securities, means the right or entitlement of a person through ownership, agreement, a relationship, or otherwise, alone or together with another person, to receive or participate in any distribution in respect of the company's securities, to exercise or cause to be exercised in the ordinary course of business any or all of the rights attached to the company's securities, or to dispose or direct the disposition of the company's securities or any part of the distribution in respect of the securities. So the beneficial interest is where it is beneficial ownership lies in ownership as well as control. Beneficial interest relates specifically to the issued securities of a company. What is the content of the beneficial interest register? As mentioned, this is detailed in Regulation 32A, and there is an example template for you published on the CIPC website on the content of the beneficial interest register and the minimum information that must be contained in that. Where you have complex ownership structures, make use of the disclosure form to provide an organogram of how this ownership structure fits into each other. And this gives CIPC an indication of what the beneficial ownership structure, complex or not, of a company looks like. The CIPC may at any time require or cause the verification of information and documentation as provided for in Regulation 5.2, which means the CIPC may at any time when we have examined the information that has been submitted, request for further guidance on further documentation, clarity if there aren't any, etc. Another frequently asked question relates to trust. Does a trust declare beneficial ownership with the CIPC? The answer is no. Trusts, although registered as or regarded as juristic persons, as I've mentioned before, are not registered with the CIPC. They are filed with the Master of the High Court, and they must declare their beneficial ownership in terms of the trust with the Master. But where we have in instances where a trust is the owner or the member of a CC or the shareholder of a company, in terms of a declaring company, the natural persons of these trusts must be declared. So the trustees in terms of the trust because of control, and beneficiaries in terms of ownership. And that is my story, ladies and gentlemen. I think we still have a few minutes left. And we can deal with a few questions. Simon, I just want to stress everybody that we cannot assist with specific scenario questions. The CIPC cannot provide you with legal advice on what your company's filing needs to look like. Our step-by-step guidance notices and FAQs that I've just highlighted, a few of them now, provides extensive guidance on the steps that you need to follow in order to declare your beneficial ownership. Thanks, Simon.
Thank you very much, Lucinda, for your presentation. It was informative, and then I hope that it benefited most of our customers. And then I checked on the chat box. My colleagues have responded to most of the questions on the chat box. And then I don't know, Lucinda, if you still have anything to say before we close the webinar. Thank you.
Thanks, Simon. And so just from my side, ladies and gentlemen, to highlight is the easiest way to ascertain the beneficial ownership of a declaring company is to apply the requirements as a type of checklist. Is my company an affected company or not? First, that's the first question you ask. Apply the checklist. Public company, yes or no. State-owned company, yes or no. Subsidiary of an affected company, yes or no. Private company owned by an affected company, yes or no. And then once you have that answer, you know which category to select. And then the second step, apply the definition of beneficial ownership as per the simplified slides earlier in the presentation and declare accordingly. I also need to stress at this point that beneficial ownership declarations must be filed on an annual basis. So we do receive a lot of queries from clients saying that they did file their beneficial ownership in 2024, but now they are being prohibited from filing their annual returns, which is due in 2025. You have to refile the beneficial ownership declaration for this current year in order to be able to submit your annual returns. So ensure that beneficial ownership declarations is filed annually and is up to date. Changes can be filed anytime during a year, but there must at least be one filing annually. I know it is a process to submit beneficial ownership declarations as well, but we are in the process of building enhancements to our register to pre-populate information that has been filed already, to enable filers to simply confirm that the information is unchanged and then upload the mandatory new mandatory documentation, the securities register, the mandate, and the IDs, but they don't have to then declare the information again, beneficial ownership information again, provided that it is still the same and they can only confirm. That is in the process. We are building enhancements to our systems to make it easier for our clients to do the declaration. And we will keep you updated as soon as all of these enhancements are in place. Make use of the step-by-step guides. I can't stress that enough. It gives you step-by-step every single step on what you need to do, how to submit your, where to click, what type of information we are asking for, why we are asking for that information, and the format that it must be uploaded in. Thank you very much, ladies and gentlemen. Thank you, Simon. I think that I've said a mouthful. This presentation will be made available to you as well on the CIPC website. You can gain access to that and all the other FAQs, step-by-step guides, and guidance notes. Thank you very much and enjoy the rest of your day.
Thank you very much, Lucinda and then Ruzani. And then a big thank you to our colleagues who assisted with answering questions. And then we have come to the end of the webinar. And then we hope it was of value to you and that you join us again for future webinars. And then with that said, I am now closing the webinar. Goodbye.